Imagine being in a scenario where a person is handcuffed without a court order or under circumstances that seem excessive. Recently, India has made changes to its criminal law regarding handcuffing, sparking discussions about citizens' rights, the role of police authority, and judicial oversight. Today, we'll dive into these changes and understand what they really mean for anyone interacting with the law. Handcuffing has always been a sensitive topic in criminal law. Previously, it was a strict procedure. Handcuffing could not be done without just cause, and judicial authorization was essential to avoid abuse of power. The new law, however, seems to reintroduce handcuffing in a way that some say could give broader discretion to the police. So, what does this mean for your rights? Today, we'll explain the recent changes, why they matter, and how they could impact you if you or someone you know encounters this law in action. Here's a quick overview of what we'll cover. First, changes in the handcuffing law. What the new law allows police to do. 2. Significance of the changes. How these could impact individual rights. 3. Judicial oversights and safeguards. What, if any, protections in place. 4. Cases and commentary. Insights from Indian courts and legal experts. Let's break down these points to understand how the new law shifts power dynamics and what it means for those caught up in the system. The new legislation, Section 43, Clause 3 of the proposed Bharatiya Nyaya Sanhita or BNS, changes previous restrictions on handcuffing. Previously, handcuffing was limited to cases where there was a risk of escape or if a person was violent, and even then, it often required court permission. Under the new provisions, however, police officers have been granted wider discretion. Now, the law states that police can handcuff individuals if deemed necessary for the safety of the person being arrested, the public, or the police officer. Although this may sound reasonable, it opens doors for potential misuse. With this broad discretion, the line between reasonable use and misuse may blur, potentially impacting individuals' dignity and presumption of innocence. These changes have stirred debates among legal experts, activists, and the general public. Why? Because handcuffing can deeply impact an individual's sense of dignity and reputation, values enshrined in our constitution. While the new law claims to balance security with rights, critics argue that it gives law enforcement undue power over citizens. In cases like Prem Shankar Shukla versus Delhi administration, the Supreme Court ruled that handcuffing should be rare and requires strong justification. The shift in policy now stands in contrast to such landmark judgments, which historically emphasized restraint. Judicial oversight was historically key to ensuring that handcuffing remained a measure of last resort. So, has the new law addressed this? Unfortunately, the new law does not mandate prior court permission for handcuffing, raising concerns about judicial checks on police power. Legal scholars and judges like Justice V.R. Krishna Iyer have previously warned about unchecked handcuffing, emphasizing that freedom should be a guiding principle in criminal procedure. Without judicial oversight, there is a potential for this power to be misused. If you or someone you know is handcuffed, it's crucial to understand the legal actions you can take to protect your rights. First, seek legal assistance. The first step is to consult a lawyer who can assess the legality of the handcuffing based on your case. 2. File a complaint. If you believe your rights were violated, you have the right to file a complaint with the Police Oversight Board or approach Human Rights Commission. 3. Approach the court. Courts can review cases of unjust handcuffing and order compensation if your rights were infringed. Cases like Sunil Batra versus Delhi administration highlight the judiciary's role in protecting prisoner rights. 4. Document the incident. Always keep records. Witnesses, documents, or video evidence can support your claim if you decide to take legal action. These steps empower you to hold authorities accountable if handcuffing laws are misused. Remember, the legal system provides avenues to protect against abuse, and exercising these rights ensures checks on power. The law around handcuffing is evolving. Let's discuss some recent updates and reactions. Recently, several legal commentators and former judges have expressed concerns about broader handcuffing discretion. For instance, Justice D.Y. Chandrachud has spoken about upholding individual dignity as a core value. Public interest organizations are also calling for further amendments to add clearer restrictions, hoping Parliament revisits this issue in upcoming sessions. This public discourse shows there is significant concerns around unchecked authority, suggesting potential for more reforms or clarifications in the near future. Handcuffing is not just a procedural action, it's tied to a person's dignity and respect under the law. With these new changes, it's clear there are important discussions to be had around individual rights, police power, and judicial safeguards. Let's recap these points that was discussed. First, the new law gives police broader discretion to handcuff under Section 43, Clause 3 of the BNS. 2. This provision marks a shift from earlier judicial safeguards. 3. Cases like Prem Shankar Shukla and Sunil Batra emphasize restraint in handcuffing. 4. If you believe your rights were violated, there are legal steps you can take, including complaints and court review. 5. Recent updates show that the law may continue to evolve, with public figures calling for additional safeguards. Stay informed about your rights. If you want more insights on legal updates, subscribe to our channel and share this video to spread awareness about our changing criminal laws. Take care and bye.